Hello all, welcome back to Business Law at Columbia College. My name is Cassandra Jenneke and I will be your instructor for this class. This is class number 10, and today what we're going to be talking about is our last unit within our contracts module, breach and remedies. So what happens when someone doesn't perform, that performance is not adequate, and we have a breach? What do you get? So a breach is simply defined, but much harder to identify because, of course, lawyers make everything really hard, right? A breach is a failure to act or perform in the manner called for by the contract. So in our last class, we talked a lot about what adequacy of performance looks like. And where performance doesn't seem adequate, we have this problem where is it a breach or is it not a breach? So that's what we're going to talk about today. Now, you can cure someone's breach by waiving your right to sue them for the breach. If you waive their breach, then you are no longer allowed to sue them, and that breach cannot form the basis of a lawsuit. So you can expressly waive, which is what I would recommend you doing if you make the choice to waive. Make sure you put it in writing, okay? That you have this intent to give up your right to sue the party for their breach that has already occurred. That's an express breach, waiver of breach. The larger problem is when you impliedly or not expressly waive. And you can do that, as I mentioned in our last lesson, by accepting future performance, right? By just going along like it never happened. That's an implied waiver. And so you have to be very careful about allowing the party to continue to perform without addressing in some way whether or not you're going to waive or not waive that breach. So if the contract continues despite the waiver, then the waiver and its scope only extends to the matter that was waived. So it doesn't allow for a party to pretend like they're ignorant of all the other terms of the contract. It doesn't excuse any future breaches. You can also say to a party, like let's say you're having something delivered from this company and you're getting stuff delivered from them every month and they have a due by date of the 15th. And one delivery you get on the 17th. And you're like, hey, listen, I'm going to accept this tender of performance, but I am not waiving my right to sue you for this breach. Okay. Put it in writing. By reserving your right to sue. Okay? If you accept defective performance, you have the option to not waive the right to pursue damages for that breach. Because what happens if it keeps happening, right? You tell them, hey, listen, I'm going to take your stuff on the 17th, but if this happens again, I'm going to sue you for it. Okay? Now, what constitutes actual breach where performance is never started? Great question, right? You enter into a contract and you're like, oh shit. Well, I can't really perform that contract. I got to tell them that I can't perform it. So I'm going to tell them that I can't perform it. Okay. This is something called anticipatory breach. This occurs when a party declares, either in writing or verbally, that performance will not be made as required. It's not going to happen. So that express declaration must be clear, absolute, and unequivocal. And it must be a refusal to perform the contracts according to its terms. It's not something like, well, I don't know if I'm going to make it there on time. I don't know if the package is going to get to you on time. That is not anticipatory breach. And the reason that that distinction is so important is because there are certain things that you get to do when you have an actual anticipatory breach and repudiation of performance, okay? You can anticipatorily repudiate, refuse to perform by conduct, okay? So if you take an action that makes it impossible for you to perform, then you have anticipatorily breached. So let's say, for example, you enter into a contract with party A to sell them your vehicle, but then the next day before you can perform, you sell that vehicle to party B because they offered you more money. You have, by your conduct, anticipatorily repudiated and breached the contract. Okay? Your conduct is the repudiation. The result is a breach. Now, why is it important for us to talk about what happens upon an anticipatory repudiation? The express or by conduct indication that you will not be performing. Oh, well, you have several options. The first of which is to remind them of when you anticipate performance happening. Be like, okay, that's cute, but here's the deal. Performance is expected at this date, at this time, and in this manner. Be there or be square. Okay? You can, that's option one, and then just wait for the actual breach. Okay? Or you can regard the contract as broken and bring a lawsuit without waiting for performance or without waiting for actual breach. So you can treat it as an anticipatory breach and say, okay, great, you've breached and I'm suing you. That is a very dangerous option. We'll talk about the danger here in a moment. You can, when somebody anticipatorily repudiates their ability to perform the contract, you can take that as an offer to cancel the contract, which you can accept or reject. So if someone says, hey, listen, I can't perform as we've agreed, you can say, okay, so do you want to cancel the contract? Recall that upon discharge, right, cancellation constitutes discharge, you guys don't go back to where you were. You don't revert to how you were as if the contract never happened. You just cancel it as of that time, and you go on your merry way with no cause of action against the other party. That's an option. I would submit to you that the first option is the safest, followed by the second, which is you having a conversation with the other party about canceling the contract altogether. It eliminates your ability to sue them, but it gives you some finality. Number 3 is the riskiest because, ooh, what happens if it doesn't constitute an anticipatory repudiation? Let's talk about it. So going back, right? If it's not clear, absolute, and unequivocal, you don't get to treat it as a breach. And then your failure to perform will constitute a breach. So option number 1 is very dangerous for those reasons, right? Number 2 is really dangerous for those reasons because it can get you into a position where the other person said they may not be able to perform, and then you take that as a breach when it's not, and then you fail to perform under the contract, so you're the one that breached. Don't do that. Don't do that. So that's kind of our look at what breach is, right? We talked a lot in our last class about what performance looks like, about what adequacy of performance looks like. If you fail to perform in a way that is not If you fail to perform as called for in the contract, or you perform in a way that is not adequate, that is a breach. Someone can sue you for that breach. And then damages and remedies is really what we talk about when we think about, like, well, what do you get for that breach? Okay? So typically, where contracts are not enforceable because the contract failed, because it doesn't have definite or certain terms, or because it was oral when it needed to be written, and a party has performed, the court can find and grant quasi-contractual remedies. So we know a contract doesn't actually exist because it's not enforceable, but there's been performance. So the measure of damages would be based on the reasonable value of the services that were conveyed upon performance. It's not necessarily derived from the defective contract, so it may have absolutely no relation to the actual amount of money that you agreed to under the contract. It's going to be based on the benefit of the bargain that was conferred by the performance. Where your contract is enforceable, but a party breaches that contract, Typically speaking, you're going to get monetary damages. Okay, those are your regular remedies. But sometimes monetary damages may be inadequate. And if they are inadequate, then the injured party can request specific performance. We'll talk about specific performance in a moment, but basically what that means is that the court can order somebody to perform. Listen, monetary damages are not going to be sufficient. You have to go back and finish what you started. Pretty rare for a court to order that because we don't like forcing people to work. It harkens a little bit too close to slavery, okay? But when we measure monetary damages, the sum of what that will be, the measure of what monetary damages will be, is the sum of money that will place the injured party in the same position they would have attained if the contract had been performed. So you are basically paying them in monetary damages the benefit of the bargain. Monetary damages can be broken up into 3 separate categories, and then compensatory damages can be broken down even further. So when we review for your midterm, you'll see that I have created a tree that talks about walking through whether or not you have a valid and enforceable contract, and then walks you through what kind of damages you're going to be owed. So compensatory damages are the easiest ones for us to understand and to calculate. So basically these compensate, it's in the name, the injured party for the damages that they incurred as a result of the breach. So there are 2 branches of these, direct and consequential / special damages, and I'll define those on the next slide. So compensatory damages are basically what you would expect, right? But sometimes there's going to be a breach of a contract and, hey, a breach happened, but there's no value to it. And so a court may order something called nominal damages, which is a small sum that establishes the fact that a violation of someone's rights under a contract occurred, but they didn't actually sustain a real loss. So we're going to give you $1. Take that to the bank. You're welcome. Breach happened, but you didn't suffer anything as a result of it. And then there are punitive or exemplary damages, very rarely awarded in contract cases, but these are damages that exceed the actual compensatory damage or actual loss, but are imposed in a way to punish the breaching party. So we're going to see these most often in fraud cases, where the court is going to make a point not only to the person that breached, but also to anybody else that's listening, that this is something you don't do because we're going to punish you for it. So the breakdown, right, on monetary compensatory damages. So we're talking about direct and then consequential damages. So direct damages are ones that naturally flow from the given type of breach that was involved. This may include damages that are incidental to that breach. So any extra expenditures that are made by the injured party to rectify the breach or to mitigate their damages. Consequential damages are damages that flow from the breach, but that happen as consequential damages are damages that don't necessarily flow from the type of breach, but that happen as a result of the injured party's particular circumstances. So in order for a court to order consequential damages, the breaching party must have been able to anticipate that if they breached in the way that they breached, that the other injured party would have foreseeably sustained that loss. And so if, you suffer a loss as a result of your special position in life that the other party had no reason or foreseeable ability to know, you're not going to get consequential or special damages. Now, I mentioned mitigation of damages when we talked about direct costs and direct damages, but this is a really important concept for you to know. When you suffer a breach of a contract, so you are the injured party, you still have a duty to limit the damages that you sustain as a result of that breach, but only to the extent that is reasonably possible. So for example, if you have a gardener who starts to no-show on you, and I don't know, your home is entered into a, you know, like a yard, I don't know, contest, and you suffer some damages or could suffer some damages as a result of their failure to show up, you have an obligation to try and hire another gardener pending your suit against the breaching gardener. And so you may, you know, if it's here local in Sonora, you may put a, you know, ad in the newspaper. Be like, hey, I'm looking for a gardener ASAP. You would not be expected to put an ad for a gardener in every single newspaper in the state of California. That would not be reasonable under the circumstances. So the injured party generally must stop performing if it's a bilateral contract. They also should stop performing to avoid running up a larger bill against the breaching party. And if you fail to do that, right, if you fail to stop, right, you keep going, if you don't try to avoid suffering additional damages, then your recovery and your remedy for the first breach will actually be less because you should have sustained fewer costs. So really, you're spending money to keep money in the future. Good way to explain mitigation of damages. Now, we've talked a little bit about how you can, by the action of parties, right, discharge performance. But sometimes you can, upon an actual breach, sue for the remedy of rescission, okay? And that is where there's been a material breach of the contract, so something actually important. And you can sue to have the whole contract rescinded. Okay, so undone. In order for something to be material, it has to be so substantial that it would defeat the object of the contract. Okay, the value of any services rendered can be recovered, and the real purpose here is to restore the injured party to the position that they occupied before the contract was ever made, right? So suing for damages puts you into the position you would have been in had the contract been performed as required. Whereas rescission, so it puts you over here, right? Contract completed, except you had a breach, and so you're in the same position you would have been if the contract had been performed. Rescission puts you back here, before the breach. It returns you to the position you were in before ever entering into the contract. So you can pick which one you want to sue for, right? You can ask for whichever remedy you would like. Mentioned specific performance a little bit earlier. So you don't get to have specific performance generally, right? Because contracts, everything can be monetized. So if we can do it in money, courts are going to do it in money. But if you have a contract that just can't be monetized, the breach can't be monetized, the damages can't be monetized, and the subject matter of the contract is so unique that it requires actual performance. And that's what specific performance does. So purchases for land, those can be specifically performed. You can be told to hand over a piece of land. Personal property that can only be obtained because it's of an unusual age, unusual beauty, it's got unique history. So a really unique object, that can be ordered specifically performed. Contracts for personal services will typically not be ordered specifically performed, okay, because it resembles slavery too much. That's what I was referencing earlier. But if damages can be measured in money, you're getting money. The court's not going to order specific performance because more often than not, it's a bigger headache for them because they have to do compliance reviews and they have to make sure that everybody's performing. Elsewise, they're going to have another case alleging another breach. Sometimes you can sue for an injunction, which is basically telling somebody to stop doing something. Okay. It's in order to refrain from doing a specific act. So a good example is like illegal dumping. It's a good remedy. And we've talked about reformation a little bit in the past, right? We don't want to rely on a court to reform our contracts, which is why they're going to be written and you're going to read them. It's rule number 2. Always read them before you sign them. But if you have to sue for the remedy of reformation, you can sue to have the court put into motion and put into the contract what you allege was missing from the contract. So it's hard to prove, right? Especially when the contract is written, because you are presumed to have read the contract that you wrote and or signed. So if you're going to do that, you have to prove clearly that there was this intention by the parties to have this be a term and condition of the contract. So you can sue for reformation. It's another remedy that's available to you upon a breach. Now, your contracts can limit the type and amount of remedies that are available for a breach under your contract. One of the things that we recognize in contract law and in our economy as a whole is that we want people to make cost-benefit analysis that are beneficial for them and for their agreements. So sometimes it may be cheaper for a party to breach, fail to perform, than it would be for them to actually perform. And so courts typically like limitation of remedies clauses because it gives them an answer without them having to come up with their own calculations. That being said, these liquidated damages clauses. Let's say, for example, you have a construction business, you enter into a contract to construct a new shopping center, and in your contract it says for every day that the contract is late, you will owe as the contractor $10,000. Okay? That is a liquidated damages clause. In order for those to be valid, you must utilize that type of clause only where it is difficult to determine what the actual damages are. Also, the amount cannot be excessive. And so that puts into effect a lot of construing by the court. If you have a liquidated damages clause, then that's valid, so start there. That means that the injured party cannot collect more than the amount that's specified in that liquidated damages clause where the defending party is bound to pay, okay? If the sum is unreasonable, those clauses will be voided. If it's not a situation where determining damages is difficult, it's going to be void. So be careful about utilizing those types of clauses because they're not typically enforceable because, again, everything can be monetized. So another, so we talked about breach, we talked about the types of damages that you can receive, right? And the types of damages that you can ask for, what remedies are available to you, right? Money, specific performance, rescission, reformation of your contract. Those are the types of things that you can ask for. Some of the other things that you can ask for, just to throw a couple more at you, include, right, this type of liquidated damages clause, okay? And you can always ask for fees, attorney's fees, because this is why most cases don't go to trial, because attorneys are expensivo, okay? Very expensive. And so in the United States, the American rule states that each party is responsible for their own court fees, okay? Lawyers' fees, court fees. But if there's a statute that allows for it, courts can award attorney's fees, court costs, even appellate costs, in fact. Those are almost exclusively discretionary, so a court never has to, never is required to impose them, but will oftentimes impose them in situations where it's really frivolous, like the lawsuit was frivolous, it shouldn't have been filed in the first place. We as lawyers have an obligation to the court system to only file cases that we think are justified and that are legal. And so if we don't do that, the court can, and often does, award attorney's fees to the succeeding party because you wasted everybody's time. Typically, courts do not like limitation of liabilities clauses because they encourage people to be negligent and to not be as safe as they should be. So if you have a limitation of liability clause, these cannot apply to grossly negligent or willful or wanton conduct, right? So intentional conduct. Those that try to do that, right, that try to exonerate people's gross negligence or their intentional acts are not enforceable. But a release of liability you can do that. So if you go skiing, when you pick up your lift ticket, you're oftentimes signing away your ability to sue the resort that you're skiing with, right? So those releases are generally binding, but they cannot excuse gross negligence or willful or wanton conduct. So that's the down and dirty on our damages and remedies section. When we meet again for our lab, we will be walking through some examples of these, and we'll be walking through some examples of what breach looks like. So if you have any questions, bring them up then. Otherwise, I will see you next time.